I think Mr. Rosen, is your camera on?
It is now.
Oh, there you are. Okay. All right. Appellant, you're up.
May it please the court, Michael Polachek for OptumRx. I would
Y-
like to reserve 5 minutes for rebuttal, please.
Your Honor, one quick question. Mr. Holacek is the appellant in one case and the appellee in the other.
Uh, I, oh, that's right. I have it
Okay.
traveling together. Yeah, I'm sorry. Did you guys talk about how you want to argue these cases
We did, but we didn't resolve it. What we had proposed is each side gets to reserve 5 minutes.
and argue the case to get argued as one OA?
Yes.
You would proceed as if you were the cross appellant and you would get to reserve time on your argument.
Correct.
You're still 20 and 20, but you each get to reserve rebuttal.
Yes.
Okay, let's do it. That saves us time. All right, you're up, Mr. Holacek.
Yes, may it please the court, Michael Polachek for OptumRx. I think there are two main issues in the King's Drugs appeal where we are the appellant. The first issue is, does a Florida court have power to enforce an arbitration agreement when the arbitration is supposed to take place in another state? I think the second issue is, did Optum allege a refusal to arbitrate such that it would be entitled to get a court order compelling the parties to arbitrate? I think the answers to both of those questions should be yes, and I'd like to talk about the jurisdictional issue first. 7 times a district court of appeals has been asked to address whether a Florida court must enforce an arbitration agreement where the arbitration takes place in another state. And all 7 times, the DCA held that it does, so long as the contract involves interstate commerce. Those cases are all in our brief. They're the Coastal Health, Mintz, Jensen, AMS Staff Leasing, Default Proof, Eastern Funding, and Trojan Horse cases. In AMS Staff Leasing, the court held it was reversible error not to compel arbitration. That agreement called for
No, so I do have a question on these cases, and somewhat harkens back to my old days as a trial judge. I went through most of the 3,000-page record on this, but I have to concede not all of it. Where would I find facts? I didn't find an answer. I didn't find any transcripts of testimony or people under oath. I didn't find any legal determination that there was, in fact, a contract or anything like that. So what standard do I look at this motion to compel in the order that follows?
Your Honor, the standard on the King's Drug case would definitely be de novo because these are legal rulings about the court's jurisdiction. The court saying it doesn't have power.
There's an Eastern District of, I think it is New York case that suggests under Section 4 of the FAA, the standard to look at is akin to a summary judgment. And if I understand a summary judgment, I look for facts. And that's why I was prompted to ask the question. In this case, I didn't find anybody testifying to anything. I didn't find any requests for admissions. So without the facts and some legal conclusions, I don't know that there's any problem or any issue in dismissing this case until it's either repled or something happened. Now,
Your Honor,
that case in, it's called Alvarez, I believe, is incorrect. That's different. But what facts are there?
Your Honor, so we did submit with our petition to compel arbitration several affidavits filed under oath, including from Optum's Vice President of Contracting, Joanna Arita, that lays out the contracts between the parties.
Under Florida rules of civil procedure, how are they in the evidence?
There was no
hearing at all on this to say, as a judge, I find the following facts to be true, or only a complaint that suggests argument.
Your Honor, my understanding is there is a little lack of uncertainty in Florida law on a petition to compel arbitration, whether there needs to be an evidentiary hearing or not. But that argument, to the extent there was an objection that there wasn't an evidentiary hearing, I think that's waived. We submitted these affidavits. We cited them to support our petition. There was never an objection by the other side saying these were inadmissible, that live testimony was necessary, that there was a dispute.
Not even an answer from the other side.
No,
there's not
the other side
statement of fact.
Not an answer, nor is there any declaration affidavit from anyone at VistaCare. No one, although we had an employee, state under oath in an affidavit, this is the party's contract. This is the way the negotiations unfold. This is why we believe there's a contract. You can look at those thousands of pages. There's not a single page from anyone from VistaCare. No one who, the owner of VistaCare, an employee at VistaCare.
I went through a bunch of them, but I didn't, as I said, I didn't go through all 3,000. I was looking after a while for specific things to answer that question, and I wanted to be sure whether I missed it or not. So I understand I should look for those affidavits. And
correct. And there was no objection to the admissibility of them.
To some degree, Mr. Holacek, is the relatively undeveloped state of the factual record in this case a result perhaps of the circuit court's conclusion, which you contend is erroneous, that it just didn't have jurisdiction to even do this, to even hear this case? Is that a possibility?
I think that's correct. And I think the one thing the parties agree on here, if you look at the end of both parties' briefs in King's Drugs, is that if this court reverses on jurisdiction, which I think we agree is a legal issue, remand would be the next step for the issues on the enforceability of the arbitration agreement, because those issues were not reached by the trial court. It's been fully briefed, I believe, to this court, but this court would have discretion to remand it back to the trial court and say, fact finding in the first instance on those issues. I think that would be one possibility here. It's really only the threshold issue of jurisdiction that the court ruled upon. And like I said, we have 7 DCA cases, all coming out the same way. We cite them all in our brief, including cases that reverse, that say Florida courts do have authority to compel arbitration if the arbitration takes place in the other state. And realize that before 1975, there was a Florida rule. We disagree with the other side, whether it was statutory or some common law rule that said Florida courts couldn't enforce arbitration agreements in other states. But these 7 courts looked at that and said, if you've got an interstate commerce contract, the FAA would kick in and would override that rule.
Okay, I would like counsel just a second, because this jurisdiction issue it interests me, and I want to make sure that I understand the basis of what a Florida Circuit Court's jurisdiction would be here. I know there's a great deal of time that gets spent talking about Section 4 of the FAA as if it confers jurisdiction to a state court to resolve these issues of interstate commerce on arbitrability. I find that a little bit troubling, and maybe you can help me work through that. To me, it seems that the FAA or the U.S. Congress in general does not grant jurisdiction to a state court to do anything. Rather, that power has to come organically from the state constitution or state statute. And indeed, and in fact, I think if I remember reading maybe in the Moses case, that really the FAA has been construed as not even being an independent grant of jurisdiction in and of itself, even to federal courts. So would it be, in your view, would it be a better or a more analytically sound view of jurisdiction to view this case in terms of the Florida Arbitration Code as whether or not a Florida court or a state constitution, state statute opens the state courthouse doors open to this controversy, and then applying the FAA or the substance of the FAA or Florida arbitration law? What are your thoughts on that?
Your Honor, I completely agree with that. I think that Moses Cone does address that issue and said the FAA does not confer jurisdiction. It's a combination of substantive rights and some procedures if you're proceeding in federal court. But it seems like a false dichotomy has been created that either the Florida Arbitration Code here applies or the FAA applies.
I'm not sure it's false, because going back to what I opened it with, I'm not sure how the U.S. Congress confers an individual state's power to authorize a state's courts to exercise jurisdiction over cases. I mean, I get they can preempt, They can say that this is substantive law that should be applied, but I think ultimately it's the people that pay our checks, the people of Florida that would decide whether or not our courts have jurisdiction and exercise state power, which is what jurisdiction is ultimately about.
I agree with
Help
that.
me through that.
Yes, I agree with that. And I think there is jurisdiction here. Circuit courts are courts of general jurisdiction. We pleaded an amount of controversy over $30,000. The only reason at all why a circuit court would lack the power to compel these parties to arbitrate is if it relied on this DeMora rule, saying that circuit courts couldn't compel arbitration in other states. And
Gotcha.
that rule has been superseded, preempted by the FAA. I think the Trojan horse case we cite explains it best. To the extent there still is this Florida rule, that has been preempted by the FAA. So I think you start with the Florida code. That explains, where we file, what the amount of controversy is. It gives the courts power generally to hear the case. And now we're asking for an order compelling arbitration. The other side saying, you can't get that because of the DeMora rule. And our response is, to the extent there's still that DeMora rule, the FAA supersedes that.
Now let me understand the scenario here. There was a letter that said, we don't like how you're doing this or that or the other. There was no denial of a claim, right? Or there was no payment at issue. It was just a general complaint about what you guys are doing with the pharmacy, correct? And on that basis, you said, well, let's arbitrate. And they said, well, I don't know what they said. There's nothing to arbitrate anyway. But that was the basis for your complaint to compel arbitration.
Yes, except
doesn't there have to be something more for the court to adjudicate? I mean, like for instance, could you not have filed a complaint in arbitration, right? An arbitration complaint in California.
We could have, but that was not required. I would point the court to the three-step process in our arbitration agreement if there are disputes. Step one, a party needs to send a letter, a notification of dispute. Second, the parties meet and confer to see if they can resolve them. Third, if they can't, they arbitrate. We were sent a form, it's even titled right out of the arbitration agreement, notification of dispute, where they said, here are the 8 disputes we have. We did the meet and confer. We could not resolve them. We said, next step, arbitrate. They said, we will not arbitrate under this agreement. We think it's unconscionable. That's when we filed our petition. Now, could we have gone to arbitration on our own? Yes, but the Florida code doesn't require it. The Florida code only requires, and I quote, this is 682.03, on motion of a person showing an agreement to arbitrate and alleging another person.
Does the Florida arbitration code apply here? Because your agreement that you're relying on says it's California law. Is it the same in California?
I don't know if it's the same in California.
Well, I mean, it's your agreement. How do you proceed under the Florida Arbitration Act on an arbitration contract that said California law governs this?
Because, Your Honor, these are rules of Florida courts, and we're in Florida court.
Florida Arbitration Act is not a rule of Florida courts. It's a statute.
It is a statute, but
it's Florida law, and you're proceeding under agreement that specifies California law.
We do, but
you haven't shown us what that California law is to authorize this.
Yeah, but I can't see a scenario in which a Florida court would apply procedures from California. For example, what venue you file the complaint in.
Here's the problem. Here's the problem you're bumping up against, and this pertains to Judge Northcote's issue here. I think he'll correct me if I'm wrong, but our state legislature cannot prescribe rules of procedure. That's a separation of powers issue. So it can't be just a procedural issue for the court to apply. It has to be that Florida Arbitration Code is a source of substantive law. I think that's what you're bumping up against here.
Understood. The code says to get an order, we need to allege a refusal to arbitrate. The FAA also talks about alleging a refusal to arbitrate. There's no question here that we have alleged a refusal to arbitrate. And the other
what does California law say? I guess that's the question. What do you got to show to California?
That's the question.
We will try to. Most states arbitration codes are mirrored off of
But
the FAA.
but your agreement doesn't say what is the practice in most states of California law, right?
Correct. No, to be clear,
We don't have the California law in front of us. It wasn't presented to the lower court.
To be clear, the provider manual does not say California law applies. The arbitration agreement says that the arbitration will take place in California. Now, the argument that Your Honor has been making, that objection was not raised below. Below, the argument was that they needed to do something like obstruct an arbitration in order for us to get an order to arbitrate.
But what you're up against, Mr. Holacek, is that under a right for the wrong reason analysis doesn't require preservation. Doesn't require that it would be argued by either party, even on appeal.
I'm explaining why the California code, for example, is not in the record, and that's because the argument by the other, we moved under the Florida Arbitration Code and the FAA, and both of them say all you need is an allegation that the other side has refused, and the argument was never made that, hey, California law is the one you should be looking at here, and that requires something different. The other side's argument has always been that they have to do something different. Obstruct, it needs to be documented, it needs to be in writing, and no case by them, whether it's a California case, a Florida case, an FAA case, has ever been cited that requires something like that to get into court to get an order compelling arbitration.
Okay, you are at your rebuttal time.
Okay, I will reserve the remaining of my time.
All right, Mr. Rosen, you're up.
Thank you, Your Honors. May it please the court. There's several points I want to address, but the first point I want to make is all of the cases that my friend Mr. Holacek cites are Section 3 cases where the court enforced the Federal Arbitration Act in Florida State Court. They are not Section 4 cases. There's a clear dichotomy. Section 3 cases are when someone has filed suit and the state or federal court is empowered to stay that prosecution. The cases under Section 4 clearly are limited to a federal district court, and
if the Federal Arbitration Act really isn't the source of jurisdiction, anyways, it's rather the Florida Arbitration Code, unless there's a contrary choice of law issue that we got to work through. That's non sequitur. What does that matter?
Well, it matters in that the court doesn't have the power. Well, let me talk directly to the Florida Arbitration Code. The Florida Supreme Court said in DeMora that, and this is an exact quotation from page 82 of the opinion, the rights of the parties under this arbitration provision stand and fall upon the contract terms, not the statutory arbitration procedure in this state. So that means whether or not the state legislature later amended the provision to eliminate the phrase if that doesn't apply, if the arbitration is going to be conducted under the law of another state, it doesn't matter. DeMora said that, and Judge Casanueva's opinion in KP Meering versus North Bay, which is applied DeMora and came to the same conclusion. So there is no jurisdiction under the Federal Arbitration Act under Section 3, which they've conceded. There is no basis in suing under Section 4 because they can file in federal court, which they did 251 times in federal court in Los Angeles, and they're specifically required under the Federal Arbitration Act to file suits in the location where the arbitration would be conducted. Since it would be conducted in Los Angeles or Orange County, they should have filed suits there. In fact, there were 251 suits filed that were consolidated, and the court in ANS Drugs, which we've provided to the court as a supplemental authority, confirmed that the issue was not ripe, that they had not gone through the process to bring suit. So they don't have the authority to bring suit on that basis. There are some additional reasons that I'd like to bring your attention to, specifically on the issue of the challenge, who should decide the issue, whether it should be arbitrators or the court. It should be the court because pursuant to Justice Scalia's opinion in Renner Center, the court said that when you're challenging the arbitration provision and not the entire contract, that goes to the court.
Well, but what about Airbnb from our own Florida Supreme Court, which that very issue came up candidly on a set of factual circumstances where the arbitrability issue being delegated to the arbitrator was even further removed than it is here. And the Florida Supreme Court held, yeah, just referencing the AAA rules that say the arbitrator gets to decide issues of arbitrability. That's enough.
Yeah, but the delegation. But that doesn't deal with the delegation issue.
No, it literally is all about the delegation issue. That was Airbnb. That was what it addressed.
They didn't argue the delegation. But they didn't argue that the delegation itself was to be challenged. Unconscionable. So I don't think they have a basis for their position. I think all the Florida courts, both the district courts of appeal and the Florida Supreme Court, there isn't a single case in which they've had authority under the FAA because they did not have right to bring suit under Section 4, and they are not an aggrieved party. And under DeMora, and the quotation I've read to the panel this morning, they don't have the authority either.
What about the choice of law issue? Where is that coming from? And how does it play out here in your view of the case?
From up to the year 2020, the provider manual said California law needs to apply. Starting in 2021, they took the choice of law provision out of the provider manual, but they left it in the provider agreement. And the two documents say that if the provider manual is silent, the provider agreement controls, so California law continues to apply. So you have California law applying. So, you know, they're subject to it. I mean, they are the masters.
Was that issue raised below? Your friend on the other side suggested it wasn't.
It was.
Where would I find that in the record?
It's in the briefing, Your Honor. I can check.
No, where it was raised to, I think it was Judge Barbas, where you all argued to Judge Barbas, hey, you shouldn't even be looking at Florida law at all. There's a binding choice of law provision here. California law controls, only consider California law.
During his 5 minutes of rebuttal, I'll look up the transcript and tell you, Your Honors.
Okay, sounds like a plan.
But, you know, it seems clear to me that they are not an aggrieved party, and they have not justified going forward under either the arbitration code or the Federal Arbitration Act. Plus, Florida law is clear that the Florida courts cannot issue an advisory opinion. And what they're seeking is an advisory opinion. There's no statement in that letter from December 2021 that states how much is at stake, for which pharmacy, for which amount. So how is the court supposed to decide that? And how is it supposed to apply which version of the arbitration agreement? The California courts have said in Avery that the arbitration, the phrase cannot be retroactively changed. And therefore, the arbitration, each arbitration provision in each provider agreement has to apply to claims that had occurred or accrued at that time. So they cannot solve the problem in 2022, or for that matter, in 2024, by amending an agreement and saying this applies retroactively to everyone. They don't have the authority to do that under Avery. Do you have any other questions? I'd be glad to answer them.
The point that you made earlier about the lack of a nexus between the pharmacy and how much is owed in nature of in the letter, was that information found in the initial complaint?
No, never.
My question on that was, in the old days in federal law, they taught that you had to have a legitimate case or controversy.
Right, Your Honor.
In Florida, under the arbitration code, I think it's 0.02. There's a clause in there, either 3 or 4 down, that uses the word controversy. You know, if somebody challenges whether or not there's a controversy. And my question, I guess, is if we're using Florida, if case or controversy has a similar if not identical meaning. Is the pleading, there's a pleading enough to invoke the jurisdiction of the Florida court? Because Judge Barber seemed to say, there's nothing here.
Correct.
That I'm looking at.
There
And
is
I don't know
nothing.
whether. Go ahead. I'm sorry.
There is nothing here because there are. They sued in California in the Eastern District of California. Central District of California. They sued 251 pharmacies, and clearly the court said there was not a ripe controversy, that they had not gone through the process to get to that point. The Florida courts can't issue an advisory opinion under Florida state law, and it's not ripe. It's simply not there.
I don't think they're asking for an advisory opinion. I think they're asking, like what they said, which is referral to arbitration in California.
They should have gone to California federal court to make that request. They could have done that in California. They did it 251 other times. They didn't do it in this occasion. I suspect it's probably for the purpose of exhausting us, but there's no basis for them doing it here. If you have any other questions, I'd be glad to answer them. Otherwise, I'll reserve my remaining time.
Okay. Thanks, Mr. Rosen. Mr. Jack, you have 5.
Thank you very much, Your Honor. I'll try to make 4 quick points. First, although we think that the other side waived the issue about the California arbitration code applying here, did just look it up, and it is virtually the same. It's California Code of Civil Procedure 1281.0.2, and it just requires an allegation that the other side has refused to arbitrate. So I know there's a question of whether they preserved the quote-unquote choice of law issue. They certainly argued that a California...
Does the California Arbitration Code confer authority on an out-of-state court to compel arbitration in California?
I don't think any state could affect the jurisdiction of another state.
Okay, so then, and looking, I think that the appellee's arguments on the FAA provisions not applying here is pretty well taken. Correct? I mean, this doesn't rise in the course of any suit or proceeding that's already pending, right? That would be Section 3. And Section 4, it has to be, the petition has to be filed in a U.S. District Court. There's nothing in here that says you can just go to a Florida state court under a state court under the FAA and compel the arbitration.
I disagree with that, Your Honor. In the Gulf offshore case, that's U.S. Supreme Court.
I'm just reading the text. Text is very popular these days.
It is, but the U.S. Supreme Court...
doing a great job of it.
Hey, thank you, Judge.
The U.S. Supreme Court, which has textualists there too, they have made clear that state courts have concurrent jurisdiction to enforce the FAA, and that references to a federal district court does not strip a state court of jurisdiction. That is the Gulf offshore case we cite and the Taflin case.
But what about a choice of law provision? If you've divested the ability of a Florida court to apply Florida law, if that indeed has happened, then how does a Florida court apply the Florida Arbitration Code? I mean, this could really get you in a whipsaw quick if you go down this rabbit hole. But help me out of it.
I think the key is FAA Section 2, which says that all arbitration agreements are enforceable, and the cases interpreting it have said that federal and state courts must enforce it. And so,
except that it says if any suit or proceeding is brought upon an issue referral to arbitration, but that hasn't happened here.
That's FAA Section.
Nobody sued anybody over this dispute.
So FAA, if we were in federal court, we would not be moving under FAA Section 3. That's what FAA Section 3 says. So I agree with that. We would be moving under Section 4. But the
so you're saying that notwithstanding the language express U.S. District Court, U.S. Supreme Court says the textus on the U.S. Supreme Court says that also means state courts?
Correct. RICO refers to U.S. District Courts. The offshore outer water land.
Yeah,
act,
but you know, like in Florida, RICO prosecution is generally under state RICO law, is it not?
Before there was a state RICO law, it could be brought under the federal statute, and the U.S. Supreme Court had to address this issue. It refers to federal courts. State courts have concurrent jurisdiction. You need something more explicit from Congress divesting a state court of jurisdiction. I really want to focus on this, because if this part of the circuit court's order stands, I think could be dangerous, because there are many federal statutes that vest jurisdiction or venue in a federal district court. And there's never been a case, I think Judge Barbas is the first opinion we found on record, that says that language means a state court is divested of power to enforce that act of Congress. And so that's something I just really want to focus on, because there's no precedent for that. And I think that would be dangerous precedent because of the number of federal statutes at issue. The last point I want to make is we haven't talked much about unconscionability. I think that in the VistaCare case, the judge correctly found that there's a delegation clause here. And so all of the arguments that VistaCare has to the arbitration agreement, whether it's retroactivity, the modification clause, costs of arbitration, lack of discovery, they all go to the arbitrator. They preserved all those arguments. They can make those arguments to the arbitrator. But because of the delegation clause, the trial court was not allowed to resolve those issues.
Okay, Mr. Holacek, your time is up. I'll turn it over to Mr. Rosen for his rebuttal.
Thank you, Your Honors. A couple points. The defendants have cited an 11th Circuit case called Ultra Kashmir versus Meyer to justify saying the FAA applies to give them jurisdiction in state court under Section 4. And it's clear, they said, the federal court's jurisdiction over even this limited number of suits is not exclusive of, but rather is concurrent with jurisdiction of the state courts, citing Section 3. And to confirm that, Ultra Kashmir then cites a 5th Circuit case, Merrill Lynch versus Haydu, Haydu, which says the United States Arbitration Act grants both state and federal courts concurrent jurisdiction over disputes involving arbitration agreements, Section 3. So it's very clear that in language of the federal courts, as well as the language of the state courts, that Florida state courts do not have jurisdiction under Section 4. Moreover, under Renner Center versus Jackson, the court said it's a multi-level process in which if the challenge is to the delegation clause itself, that is not for the arbitrator, that's for the judge to decide. And there's an additional case that we cited as supplemental authority, Bielski, B-I-E-L-S-K-I versus Coinbase, decided by the 9th Circuit just last month in December, which said that rejected their position as well. So
I would suggest to you, counsel, that ship has sailed on the delegability issue to the arbitrator to decide arbitrability. I mean, Airbnb is pretty clear on that. I just don't know how you get around that.
Well, let me point you to the transcript. I'm looking at the transcript right now of VistaCare, in which we raised the issue on page 22 of the transcript, where we said the clause that was in existence for the 6-year period required that it be governed and interpreted under California law and required that any arbitration be conducted in California, specifically in Orange or Los Angeles County. So we preserved that issue. Page 32. And also on page 32, there's a reference that says, an Optum for 6, this is page 32 of the transcript, an Optum for 6 years from 2015 through 2020, and it had an arbitration provision that says you're governed by California law, and that's what applies here. And under California law, the applicable arbitration agreement is the one that provider manual that existed when the claim accrues. Under Avery, they can't go back and change the rules. So I think that bars them. And so if the court is going to deal with this, you're going to have a series of issues with each agreement, with each order. You have to go back and say which arbitration clause applies, which doesn't apply. And you can't simply give them the power that says we can retroactively change the rules of engagement going back to when time started. They simply don't have the authority to do that. If you have any other questions, I'd be glad to answer them.
I think we're good. Thank you both very much.
Thank you.
In
Thank
order
you, Your
to
Honor.
in order to leave our courtroom, you click the leave button, which is in the corner, I think the lower right corner of your Zoom screen, and you'll disappear, at least from our view. There you go. Okay. The court will be in recess for 10 minutes.